on mute. So what we're going to ask you to do as we proceed is if you think of questions, either right now or as you listen to some of the great information that'll be provided, go ahead and put a question in the chat. We've got people watching for them. They'll keep note of them. And later on, we're going to do a Q&A. The recording will stay on all the time, except we'll turn the recording off when we do question and answer with our federal panel. So, but throw those questions in anytime they come up, and just know that you're going to be on mute. The slides will be provided. They will be posted on the DAISY website. There will be an evaluation after. While the presentations are going on, you'll notice one of our colleagues is going to be putting links in the chat. So watch for those links. You'll get them, of course, when you get the slides, but in the meantime, while someone's describing something or discussing a resource, a link will appear in the chat so you can see them that way. I'm going to take a minute now, and I'm just going to introduce us, and then we'll see who you all are. And then we'll talk a little bit about the agenda and then move right into our content, because we have a lot of great content to share with you today. As you probably know, if you've been around a couple of years, this is a very popular webinar. We try to do it at least once a year. We try to also do it in person whenever we can. So we're very appreciative of our speakers who are coming today. You see that the webinar is co-sponsored by 4 entities, by the U.S. Department of Education, by DAISY, by ECTA, and by the Policy Office. And so why don't we go ahead? I'm going to ask you to go to the second slide, and I'm going to actually introduce the 2 main speakers. Surprenant, who many of you probably know Frank as well, is Senior Counsel in the Office of General Counsel, and that's in the U.S. Department of Education. So the same department where OSEP is located, but a different office. Frank Miller is the Acting Director of Student Privacy Policy Office, which is also in the U.S. Department of Education. And Ross Lemke, who I'm sure many of you know, and many of you have reached out to for excellent TA, is the Director of the Privacy Technical Assistance Center, funded under the U.S. Department of Education. We all fondly call it PTAC. And then myself from DAISY and ECTA. So now you know who we are. So on the next slide, we're going to pull up a poll question, and we're going to ask you if you would tell us who you are. So again, we can all get a sense of who's on this call. So Mallory's going to pull up the question. What option best describes your primary role? And we'd appreciate you answering. Good, lots of people are answering. I'm going to count on Mallory to let us know when it's a good time to view the answers. If you're just joining, please put your name and your affiliation in the chat. And your state would be helpful, and then we all kind of know where issues are coming from. Looks like we've got a good participation rate, maybe another couple of seconds. Oh, thank you. Everybody's answering, which really helps. Okay, what do you think, Mallory? You think we have a good enough response for now?
Oh, absolutely. Yeah, I'll end it and show everybody.
Great. Thank you for adding your name and your affiliation. And then we can see very, very, very nice spread of participants. We've got Part C coordinators and data managers. 24% of you fall into that category. Other Part C state staff, 25%. We have 3% are Part B 619 coordinators or data managers, and people are still joining. So we're not going to have everybody reflected in this poll. I can see people still joining as we're talking. We have other Part B state staff. And then we have quite a few, which is great, local or regional providers who will bring a different but necessary perspective to these issues, 17%, and then some national and state TA providers. Thanks, everybody. That's great. Okay, so let's go to the next slide. We're just going to briefly review the objectives for the session and the agenda, and then we're going to get started. As you join, keep putting in your name, please. So here are the objectives. You'll learn about policy and data trends, particularly that impact privacy. We'll examine best practices for protecting your PII, personally identifiable information. You'll gain an understanding of parent consent, and there's lots of issues around the nuances around parent consent that we're going to explore today. Review the role of participating agencies, and then also identify options for data sharing. So that's quite a large, a significant scope. So we're going to move along, and on the next slide, we'll share the agenda. As you can see, there will be some chunks of information that we're going to move right into now. First, Kala and Frank are going to talk a little bit about the trends that you want to be aware of as we discuss privacy and data. And then they're going to back up a little bit and give us all a very always needed overview of IDEA and FERPA. Some of you are very new, some of you have been around a while. We always have to refresh our memory on the provisions of IDEA and FERPA. And then the third part, Ross will help Kala and Frank apply that knowledge from the first two topics into some key issues. And they got those issues from things that you all talk about when TA is involved or when you've raised questions in meetings. And so it should be right on target with what you're looking for. Then we'll go over some resources quickly. And then with any luck at all, we'll leave 20-25 minutes to turn off the recording and do some questions and answers, which we will take them from the chat. So any questions you have while you're listening, throw them in the chat or be prepared to put them in the chat later in the webinar, and we'll all be watching for them. So don't worry about them getting lost. On that note, I think if we change slides, I'd like to turn it over to you, Kala.
Thanks, Sharon. And thank you all for joining this afternoon. I thought it would be helpful to give a quick background on what are some of the trends that we're seeing at the federal and national level that are affecting IDEA, both Part C and Part B. And the biggest trend we're seeing, and you can see on this list here, and you don't need to take notes when you get the PowerPoint, and thank you, Grace. She's put the links into the chat, but when you actually receive a copy of the PowerPoint, the links are also embedded in the PowerPoint, so you'll have those. Are 4 documents that were issued relatively recently by the U.S. Department of Education, as well as in collaboration with the U.S. Department of Health and Human Services in the early childhood space in particular. The first is a child find document, but the child find document is actually part of a series of technical assistance implementation guides, where we at the federal level have been modeling what we're hoping to see also at the state level, which is interagency coordination on early childhood across multiple agencies, including our health department, which is HHS at the federal level, the Department of Education, and specific programs, everything from EDI, which we collaborate with CDC at the federal and national level, as well as the McVie program and other programs that work closely, particularly with the IDEA Part C and preschool programs. This series of guides was developed through a federal interagency informal work group. You'll continue to see more information about that. I think they're actually doing a webinar today and additional resources that are on our website. The second document that's referenced regarding Head Start really talks about the importance of creating high quality, inclusive early childhood systems and how the Head Start program, that's a joint letter from the Department of Health and Human Services and the Department of Education, really requires collaboration across multiple programs, and understanding how IDEA children are served in those programs requires us to ensure that we have a mechanism to collaborate, whether that's a formal interagency agreement, as well as other vehicles for communicating and establishing regular relationships, regular meetings to build relationships, as well as other structures. The third document is about inclusion more broadly in all early childhood programs, not just Head Start. And the fourth document just came out in August of this year. It's a Dear Colleague letter on the importance of coordination between Part C and the EDI, or early hearing detection and intervention programs. All of these policy trends, which are really a policy trend that is not affected by partisan politics or changes in administration, but really are the trends we're seeing in the education and early care and childhood communities to ensure that we are catching all families whose children have service needs, both to identify them, but ultimately to serve them and improve outcomes. And the way in which we can do this best is to ensure that the coordination is not just at a high level at the state, but really down at the local level as well, whether that's at the school district level, school level, and or early intervention service provider or Head Start program level. And that is a big part of that we're getting a lot of TA requests for, both in our K-12 school districts, as well as our early childhood programs and IDA Part C, requires data sharing. And it's really important to us at the Department of Education that if data are shared, particularly if they include personally identifiable information, that everyone has an understanding of how that occurs, that it's done effectively for the right purposes, and with recognition of the applicable privacy requirements. So that's a critical program trend. Next slide. And what does that mean for our IDEA programs? It means that if you're looking at entering into some sort of agreement that is about interagency coordination, it isn't about determining, oh, I have an agreement, therefore I can share any data. That's not the approach. The most critical question to start with is not what data I need to share. That's not the question we should be asking. And if you attended my session with Christy Kavalek at the OSEP Leadership Conference, you heard this ad nauseum. What's really critical to start with as your first question is, why do I need this interagency coordination? What are my purposes? Am I trying to improve my child find and identification rate? Am I trying to improve reading outcomes? Who else needs to be at the table to look at and what services are impacting those potential outcomes? Identifying the purpose and the outcomes for any data sharing is the critical first step. And that is why we're having a session on privacy here today. But there are also other trends that are impacting why we're talking about data sharing today. For that, I'm going to turn to my colleague, Frank Miller, who oversees our Student Privacy Policy Office that administers FERPA, and we work together. I also work on IDEA confidentiality, and both of those statutes have to be read together. Frank, what are some of the trends we're seeing in the data side that impact the privacy lessons that would be helpful for us to hear?
Thanks, Colin. If we could kick over to the next slide. So it was in preparing for today's session, I was reflecting back on the almost 13 years since I was a Part C and Part B 619 data manager. And so things have changed. And so let's highlight some of these because it impacts your work today. First thing is the Evidence-Based Policymaking Act of 2018. So what this does is it really focuses on open data. We hear a lot of questions on how can we use data to make decisions. I know when I was at the state level, it's how can I get more money for our programs? How can I show what data trends we're seeing? So there's a lot of focus over the last 5 years, which is the 5-year anniversary of the evidence-based policymaking, on the use of data and making it more transparent and more available. So with that, there comes some potential pitfalls, right? If we have more and more data out there, now we have to have much greater awareness on data incidents. And while we see this a lot at our schools, right? You see the data breaches in the news, the paper, but we also have to worry about that on a Part C, Part B perspective. We have a lot of sensitive data that we're sharing, and we have to make sure that, how we're protecting it, a lot of more public attention on the data incident. So this is something that, I fortunately, I didn't have to deal with as much back in 2011 and before, but now we're seeing much more prevalence on data incidents and the public aspect of that. We're also seeing a lot more use with third parties, right? So we're using third-party vendors, party apps that help support our programming, whether it's tools to help track some of our data. Maybe it's tools we're using to help determine our child's progress on his IFSP or his IEP. But there's a lot of third-party apps that our programs and our schools are using to supplement some of those services, right? When you're using third-party apps, a very important part of protecting that data is having those written agreements with those various third parties, and what do they entail, and what should we cover, and how are they going to use the data we're sharing with them. Unfortunately, although I could talk probably all afternoon if Kala would let me and if we had the opportunity, we have some time limits. So I think today's session is probably going to spark some things that you may want to follow up on later. And you'll see at the end, we have some great resources. So don't let today's session overwhelm you. It's just really to put some things on your radar and then try to help provide some clarity. The last bullet point on my slide here is multiple platforms for communication. So we're seeing a lot of different things, right? Before we maybe call a family and schedule a session, we're going to go out to the home and provide PT or speech. Now we're doing things through text messaging or other social media platforms. There's just a whole host of different ways we communicate. We also have a very vibrant parent group that we deal with that have Facebook accounts and Instagram and Snapchats. So we're seeing more and more things showing up on there that those are all some considerations on, when you reply back to someone, is it, how is that going to be taken? So there's a whole host of trends that impact privacy that maybe on the surface you don't really think about on a day-to-day basis, but we at least have to have this on our radar for considerations. And with that, I'm going to turn to the next slide. And I think, Kala, you were going to cover this one.
Thanks, Frank. So IDEA and FERPA, the Individuals with Disabilities Education Act, has been around for a while. Part B has been around since 1976. Part C and the preschool program under IDEA Section 619 since 1986. Regulations were last amended in 2006 for Part B, 2011 for Part C, and an important exception was added to FERPA in 2012, which is the audit evaluations exception, which we will talk about later today. IDEA and FERPA are two separate authorities that really have different purposes, but they overlap and are common in one goal, in that they protect the privacy and confidentiality of children's records, and particularly to personally identifiable information, or PII, which we'll talk about a little bit more. And that information, which is personally identifiable information, is protected through both IDEA and FERPA. So when you're looking at any records, education records, early intervention records that contain personally identifiable information, that is information that you need to protect and have responsibilities. Under IDEA, you have responsibilities as a participating agency. Under FERPA, you have responsibilities if you're an educational agency or institution. Next slide. So when do IDEA and FERPA apply? They apply if and when personally identifiable information is disclosed under FERPA from an education record that is maintained by an educational agency or institution. That's really critical. If it's not maintained, and what does that mean? Does that mean something I'm required to maintain, something I'm actually maintaining? Oh, there's a lot of interpretations out there about that. We're not going to, we can spend an hour on that, but we're not going to. But that's when it applies. IDEA applies, IDEA's privacy provisions apply when personally identifiable information, or PII, is disclosed from either an early intervention record under Part C or education record under Part B that is collected, used, or maintained by a participating agency. And that definition of participating agency varies between IDEA Part B and Part C. So what is PII? Next slide, please. Frank, since FERPA started with that definition before IDEA, maybe you can share with us, what is personally identifiable information?
I would love to. So personally identifiable information, or PII, I think this is something that we probably, when we hear the term personally identifiable, many things come to mind, right? A name of a parent, name of the child's mother, name of the student. Also address, where they live, how do we, that information we use to send out mailers. One thing we don't have listed on this slide is email address. That usually goes hand in hand with address. So it's address or email address. But other things, date of birth, place of birth, social security number. Now, certainly in a lot of our systems, when we're collecting social security numbers, we have a lot of extra protections on that, but that's typically personally identifiable. You can use that to link to one student, right? Names of parents, other family members. So some common concepts that when we typically hear personally identifiable information, a lot of these things come to mind. But in the FERPA world, and then Colin's going to talk a little bit about the IDA context, there are some other considerations we need to have in addition to the kind of these more straightforward examples of PII. And if we can go to the next slide. So in 2008, when we looked at our definition of PII, we added two kind of caveats to that. And it's really important to point these out as a little bit later, we're going to talk about de-identified data and why these two additional components are important. So the first one is any information that alone or in combination is linkable to a specific student that would allow a reasonable person in the school community the ability to pull those things together and with reasonable certainty identify the student. If you've ever sat through any of our PTAC FERPA 101s, Ross and his team do a great thing where they look at Captain Hook for you Peter Pan fans, and we look at some spreadsheets where you have a spreadsheet and you have the person's name and you strip off the person's name, but all the other columns and data points in that spreadsheet really help you to identify that it's one specific student. In that example, it's Captain Hook, where the individual has a patch, a hook for an arm, and a fear of crocodiles, right? So any of those three things in isolation probably wouldn't let you identify, but when you put it all together, you're able to tell who within reasonable certainty it is. So if you're a school district that has a very small population of visually impaired students, and only one of which happens to be of Asian descent, it's probably pretty easy if you have some of those indicators in a data set that you're talking about this one student. So that's the reasonable person. Years ago, we called it easily traceable, but we've updated that to include anything that is linked or linkable that you can link that back to a specific student with reasonable certainty. The second thing we added, and you see this in the context of a media request. So there was some kind of incident that happened at, a football game was one example that sticks in my mind where everybody knew what happened. So when the media said, hey, we want all the information on that one unnamed student who was the subject of the fight during the football game, well, everybody knows who they're referring to. So that's where information that is requested by a person who really knows the identity of the individual, even if you strip out name and maybe some of the other PII, the requester really knows who you're talking about. So these are things where not necessarily do you think of when you think of personally identifiable information, but in the context of what we're going to be talking on in the later couple of slides, has a huge impact on how we look at some of the other data we may share. And I think Kala is now going to talk a little bit about PII from an IDA perspective. Kala?
Hey, thanks, Frank. So what else is PII? Basically, the IDA Part C definition refers to the FERPA definition of personally identifiable information, and Frank just reviewed that. We have a nice translation provision because we don't have students in the birth to 3 population. We refer to them as child or children or infant or toddler. And for schools, obviously, we're not serving children through school settings. We talk about early intervention service providers. And in Part B, the language is slightly different, but the same really standard applies, which is, can you, with reasonable certainty, identify who that child would be? It used to be that we didn't have the kind of data we have available. But today, with statisticians helping us, we are so surprised at how much of our data, when you cross-reference it with other publicly available data, whether it's census data under IDEA, the EDFACS data that state educational agencies have to report out, health data, we have to really be careful. At the federal level, we are required, for example, to cooperate with GAO, and when they do cross-cutting data studies involving IRS data or HHS child support enforcement data, we actually have to put in protections in place to not disclose PII, because if you cross-reference each of those data sets, even with names that are not published, or other what we think of as most identifying criteria, if there are locations, income, and other identifying pieces, you might be able to, with reasonable certainty, identify individuals. This has become even more important now as more and more data sets are becoming open. And so that's something to think about in the IDEA set, because disclosing that a child has a disability is also PII. IDEA requires parent consent before you can disclose any personally identifiable information, or there are certain exceptions, and we will talk about what those are. So what does parent consent mean under IDEA? Next slide, please. Under IDEA, consent must be informed, must be in writing, must be voluntary, and consent is provided for multiple reasons under IDEA. What we're talking about today primarily is consent to disclose privacy or personally identifiable information. So we're really talking about consent for privacy purposes, not for service provision in general. Frank, what are the requirements under FERPA again for consent?
Thanks, Kala. So under FERPA, you'll see some parallels, right? So we have the consent has to be written, no oral verbal consent in FERPA. It has to be dated and it has to be signed. So those are kind of the big three caveats. It has to disclose what information will be shared, but you'll see a lot of parallels between IDA Part CB and FERPA in terms of the content of the consent. And I think Kyle is going to talk a little bit about it, but a resource that we have at the end is our IDA crosswalk, which it's a resource that parallels or lays out all the requirements under IDA Part C, Part B, and FERPA. So as you're trying to navigate these things of, well, what's consent under IDA versus FERPA under B, B, C? So it lays all them out, and we've actually updated it, what, 2 years ago to try to make it even better than the original version. But it's a really good tool to kind of help you navigate the similarities and also the differences between some of the regulations and requirements. Kala, back to you.
Yeah, next slide. So how can you share personally identifiable information? Everyone knows the left-hand column, you can share with parent consent. And we describe what parent consent is. But there are ways in which you can share personally identifiable information and data that contains personally identifiable information that comes from early intervention or education records in one of these ways. Basically, there are three main ways. The first is that the data does not contain PII. You have de-identified it and it is aggregated, meaning these are sum totals. And that is part of the challenge. And you're going to need both maybe to consult with your statisticians and maybe even your counsel to ensure that you are meeting the privacy requirements of what is considered de-identified data. We have standards in our EDFACS, our IDA section 618 data of what we use as our thresholds. There are other ways to mask data. There are different privacy tools that you can use. And we are continuing to learn in this space as AI is making it even harder for us to figure out how to keep data private. So that's the first way, is the de-identified or aggregated data. The second, under IDA in particular, is if you are part of a participating agency, which for Part C, it's this big umbrella, right, of what the state uses to communicate and who is serving children. And it may be an interagency model. If you're part of that participating agency, in that umbrella, if you will, you may be able to share information, including personally identifiable information, without getting parent consent, if the purpose is to serve that child and you're part of that service delivery. Similarly, under Part B, you may be able to share if you are part of the participating agency. And then the final way is that there are exceptions. There are separate exceptions under IDEA, and then both IDA Part B and C, confidentiality provisions, reference the exceptions under FERPA. So you always want to start with IDA first and read those exceptions and read how they're incorporated, how the FERPA exceptions are incorporated into IDA. Today, we are actually going to talk about a couple of those exceptions, the Uninterrupted Scholars Act, which stands for USA, and audit evaluation exception. Next slide, please.
So I'm going to start, if you don't mind, Kala, just re-emphasizing 2 points that I talked about a little bit earlier with de-identified data. So in FERPA, there are specific provisions that said if it's de-identified data, it doesn't include any PII, you can share that without having to worry about the FERPA protections, without parent consent, without, because it's de-identified data. And I say that with a great pause, sigh, word of caution, because if you remember a couple of slides ago, I talked about those things that are linkable to a specific student. So even though you think you may have stripped, some of the personally identifiables, as Kala said, we got to remember there's a whole host of different data sets that we're reporting out on. And what used to take probably a statistician hours, if not weeks, if not months, to scour all the different data sets available on the web to try to cross-match and collaborate and figure out identities of students. We now have, as Kala reminded us, these AI tools, ChatGPT or whatever other tools may be out there, that what used to take a huge amount of time and was probably, we could say, unreasonable to think that you could draw a linkage, can now be done in seconds by some of the AI tools. So it's not to be like the doom is gloom panic, but just to be cognizant of, like, when you're reporting data, just remember that even though in the example we use is where you strip off a column that takes the name off, if there's a lot of other data points there that, you're looking at this data disclosure versus this one, you put it together, you could be disclosing information. We see this a lot with masked cell sets. So you have a small group of students that you've masked in one report, but another one, it's not as masked. And when you put them together, it's easy to discern. So I think while you can share de-identified data or aggregated data without consent, you also just have to be careful that you've looked at it and you've really taken steps to make sure that while you think it's de-identified, that it is truly de-identified. And I think Kala is going to talk a little bit more in depth about participating agency over the next couple slides. Kala?
Hey, thanks, Frank. We do have a slightly different definition of who is considered a participating agency under Part C versus Part B. For Part C, we talk about any individual, agency, entity, or institution that collects, maintains, or uses that PII to implement the requirements in Part C. And that those requirements can include evaluation and assessment. They're not just about service provision. And the second bullet just confirms, yes, if you're also using the information to provide services, you're part of that participating agency. And the third is generally if you are just a primary referral source, such as a physician who's referred a child to the Part C program, or you're a entity that serves as solely as a funding source, like a private insurance company, you are not considered part of the participating agency in Part C. We don't have those disclaimers in Part B. It's a broader definition in Part B. So just recognize that for preschool and school-age children. Next slide, please. And then there are exceptions. I'm actually going to turn it back to you because I think these exceptions are exceptions under FERPA, although IDEA Part B and Part C cross-reference these exceptions and apply them in slightly different ways. There's some nuances. But I'm going to have Frank talk first about what the exceptions are, and we might describe how they're nuanced when we talk about our scenarios.
Yeah, thanks, Kala. And as Kala said, we have probably 13, 14 different exceptions to written consent where the prior written consent of the parent isn't needed to disclose. As we said earlier, we could talk for hours, but today they've given me enough time to cover two of the more prevalent ones that I think impact you in the Part C, Part B world. The first is the Uninterrupted Scholars Act. And if we can go to the next slide. This is our most recent exception. It was signed into law in January 2013. and it permits the disclosure of education record of children placed in foster care with the Children and Youth Agency, right? So back in, I think like 2008, we had this Fostering Care Connections Act, which required at a state level, we want our children and youth systems to really collaborate with our education system, because we have kids that are getting put into foster care and it's really disrupting their educational placement or their educational experience. So while that was a great approach to take to get schools, educational side to talk with their children and youth side, unfortunately, they forgot about the impact of FERPA. So while there is this driver to do it, there's no mechanism to share that information. So in 2013, the FERPA regulations and the statute were amended to include the Uninterrupted Scholars Act. And the big thing is, if you have an agency caseworker, the school educational component can share information with that agency caseworker, local child welfare agency. The big emphasis on this is it's only for those kids that are placed in foster care. I know as a former caseworker, I wanted information from the educational group on everything on any child I was responsible for, those that were placed outside the home as well as those that I had protective custody of. Unfortunately, or fortunately, the USA only covers those children that are in foster care. That can be a group home or a residential placement, but they're placed outside their child's home, outside their parent's home. This allows for that disclosure. And it also covers, we get occasional questions on some tribal organizations that have their own child welfare agency. They would also be covered by this exception to prior written consent. There's also the second exception I want to talk about is our audit and evaluation exception. And if we go to the next slide. So typically at the state level, you have data that you have to, if you're a local program, which I used to work at, you have to share data back to the state. And the state uses this to evaluate the effectiveness of the programming that they're overseeing. How they're doing that under a FERPA perspective is under our audit and evaluation exception. If you want to look it up, it's 9931A3. And this can be to employees of the state education authority, or maybe their authorized representative. Let's say they partner with one of the larger state universities in that state, and they do all the data collection to do the evaluation on behalf of the state educational authority. That's all happening under the audit and evaluation exception. And as you can see, that highlighted in the blue banner about this information must be protected. That's really kind of like a thought as you are sharing information with those outside. So if you're using a university, you probably have you need to have some kind of written agreement with them, so they know that once they've done whatever evaluation you've asked them to do, they can't hold on to that data indefinitely. They have to destroy that. The other caveat of audit and evaluation is for the enforcement and compliance of federal legal requirements. If they're getting an IDA program grant, there's certain things the state has to do under general supervision that they're going to need data to do that. So those are just a couple examples of the exceptions. There are many more, but for today, that's where we're going to leave you. And I think we're getting ready to jump into the first issue. Correct, Colin?
Yeah, I thought it would be helpful if we could talk through some of the different scenarios. So I think we're going to ask Ross to facilitate this section to talk about some different scenarios. Ross.
Yeah, absolutely. Thank you, Kala. Thank you, Frank. All this background information is, critical. It's obviously super helpful. But a lot of those of us on the call kind of have to interact with these issues on the tactical level. People that are actually dealing with the families and kind of dealing with some of the nuance between FERPA and IDA. So our first question, if we can go to the next slide there, it just seems like a really basic one. What is a parent? Well, on first glance, well, that's a pretty basic question, mom and dad. But then, as you start to drill into it, it becomes far more complex because, families look differently now than they did in the 70s. So I've kind of taken all of these questions and kind of this question's probably been asked dozens of different ways, but kind of distilling it to one sort of basic fundamental question to kind of encompass a lot of the different scenarios. So Question number one is, a child is referred to the IDA program from the Child Welfare Agency. Child is placed in foster care and is living with foster parents. The child's biological parents have declined to consent to disclose information back to the Child Welfare Agency. Can you talk us through how, like, we might actually be able to navigate that situation?
Absolutely, Russ. Next slide. So IDEA's definition of a parent is more specific. And when you look at who is a parent for purposes of IDEA, you really need to look at the IDEA definition, not the FERPA definition. And that includes in IDEA Part B, 34 CFR 300.30. You'll see that in the crosswalk. You don't need to write it down. But also in the Part C regulations at 34 CFR 303.27. The definition of a parent includes the biological or adoptive parent in the first definition, and also includes a foster parent, unless state law, regulations, or contractual obligations with a state or local entity prohibit that foster parent from acting as a parent. And that is complicated, but basically it's making sure that that foster parent doesn't have a conflict of interest. So can the foster parent serve as the parent? Yes, under both IDA Part B and Part C, under those regulations. However, you really need to look at the different sections. For example, there are additional folks who can serve as the parent, a guardian, as well as an individual who is acting in the place of a biological or adoptive parent, such as a grandparent, step-parent, or other relative with whom that child lives, or another individual who's legally responsible for that child's welfare. And when we're looking at who do we pick when we have those choices, we actually have provisions that identify priorities. In Part C, it's explicit in the regulations that generally under the regulations, if a biological or adoptive parent is available, then you would prioritize that individual over the foster parent or the other individuals. So there are multiple people who can serve as the parent for purposes of IDEA for providing parent consent to disclose personally identifiable information. This also is true under IDEA for other purposes because you have to obtain parent consent, not just to disclose personally identifiable information, but you need parent consent to obtain an evaluation of a child. You need parent consent before you can provide services. So in these other contexts, the definition of parent is critical. And today we're primarily talking about parent consent to disclose PII, but these definitions also apply in other contexts. Hope that's helpful.
Yeah, thank you very much. Can we move on to the next slide? Because again, same vein with parent issues, it's actually probably one of my favorite parts of doing a FERPA 101 in person is when I get to the section on the rights of parents and, custodial versus non-custodial. I'll finish the section, then about 7 people in the audience will all raise their hand because everybody's kind of got their own special case, special situation. Mom and dad are divorced, dad hates mom, or mom hates dad's new girlfriend. So it may not come as a surprise to many of you that not all, parents agree on everything. So can you talk to us a little bit about how to maybe navigate some of these situations, such as like when, the parents are divorced, and has sole custody, and then, where the doctor is requesting information and, maybe one party consents, the other party doesn't consent. How do you navigate that without angering everybody or getting yourself in trouble?
Yeah, I think these are hard scenarios, and you all have dealt with them. And I know that there are many permutations, including you have to look at what state law defines as who has legal authority. But in general, in all of our state laws, which are based on common law, in one jurisdiction we've got that's based on civil code, both parents, both biological parents, or in the case of adoptive parents, if there's more than one adoptive parent, both parents generally are presumed to have the authority to provide that consent, that written consent required under FERPA and IDEA. But family disagreements are difficult, and it's really important to document the communications you've had with each parent and to determine whether or not what is the source of the disagreement, but also to communicate that if somebody who has that authority to consent provides that consent to disclose that information, you have authority to do so, but you also have discretion to determine if that is also part of something that you may need to bring up. But in general, if someone has authority both for IDEA PII disclosure, but also for service provision, it is you have authority to move forward, but you have to look at in what context. So that usually the disclosure of PII isn't happening in a vacuum. It's, as you said, for example, it may be a doctor who's requesting, or a primary referral source who's requesting information, and you may need to check with the doctor, like, who asked for that information? You know, is that consistent with the parent who provided the consent? Who takes that, you know, who's the person that the doctor communicates with. For an IFSP meeting, you also need to know, like, who's been attending those meetings, and ask, you know, is that the person who's going to provide the consent when the third party is there to, you know, to whom that disinformation is going to be disclosed. So you need a lot more context. It's not just, oh, this is for PII, I've got a parent, check the box. Why is that information being disclosed? What records are being disclosed? For what purpose? So you want to document all of that, not just the, oh, I have a parent, check. They provided consent, check. That's probably too simplistic. So those are some of the things that you'll need to both ask those questions, but then document those communications.
Thank you, Kala. So I'm gonna kind of move off of parents for a second. Let's can we go to the next slide? So let's go back to primary referral sources. So earlier you talked kind of talked about some resources that the office has put together in conjunction with other agencies. But for some of these referral sources, such as EDI programs, or even just, you know, a physician that's made a referral, and that, you know, like we just talked about in the last slide, they want to know what happened to the kid. Did they did the child get accepted to the IDA? Is found eligible for services under IDA? Were they even able to reach the parents? What information, if any, can be shared back with those referral sources?
Thanks, Ross. You know, the information is, again, you have to look at what is that purpose for sharing of information. So don't just look at what is the information that you're trying to share, because you really do have to think about that first, but also why are you sharing it? And in the case of primary referral sources, both IDA Part C and Part B require you as an agency to implement child find to identify children as early as possible. As part of that child find mandate, it's really important to note that you have to figure out why are you sharing that information. For example, if part of the reason that you're getting that request is because the primary referral source, whether that's a physician or another agency, if it's another agency that's actually been involved with that child and is also providing services to that child, it may be that they need to know that information because they want to coordinate the services to ensure there isn't duplication. Well, that might be something that you might need to list on the IFSP or IEP. You may not be aware, for example, that the Child Welfare Agency also has other services that are being provided to that child, or the EDI program is also providing services that the Part C IFSP team might also be considering. Those other services need to be reflected, and there may need to be coordination, in which case that referral source may be more than just a referral source. They may be part of that umbrella that I talked about and be part of that participating agency. This is something that you want to think through, because once you're a participating agency, you actually have obligations. You have to comply with IDA confidentiality. You cannot redisclose that information to others. And you need to meet the other privacy requirements, including keeping a record of disclosure. There are other requirements that we're not reviewing today. But if that's the determination that you're part of that participating agency, whether that's under Part B or Part C, then you may want to figure out what's the best way to provide that information, but you can do so without parent consent because you're providing it for the purpose of coordinating services for that child. That's the general response. So certain information, for example, such as child find information like, hey, did you ever get a hold of the child? Or did you ever get a hold of, more likely, the parent? That information you can provide more. You can provide emails, phone numbers, other information that we normally consider PII for the purpose of child find, right? That's okay, because that's part of the child find mandate. Even going back to the referral source, like, we never did get a hold of the parent. Do you have other information? Have they been in recently? So that's the IDA program, asking the primary referral source, hey, what's your last contact? That primary referral source may have an issue under HIPAA in terms of providing that information to you, but they are not precluded under IDA FERPA of sharing that information with you. So they might say, we can't tell you. Or they might say, yes, they were just here, in the EDI program. We call them, do you have the right number? Yes, you can exchange that kind of information for child find. And if they're part of the participating agency, you can exchange information that includes PII without parent consent. Otherwise, unless you have those, either child find information or you're part of that participating agency in general, or you have some sort of exception, which we're going to talk about later, or a written agreement in general, then parent consent would be needed. And that answer is not different under Part B if you're part of that participating agency or you're communicating for purposes of child find. So whether it's for Part B preschool services or for Part C, it's helpful to know that you're communicating for that purpose and you are part of the participating agency. If there's some questions about whether you're a participating agency, it is not a bad idea to document that either through written policies or an agreement. I just saw something fly by in the chat, which I can only see for like a second and then it disappears from my screen. It's not a bad idea to have a written agreement, because that, and then we are going to talk about what those agreements are looking like in later scenarios. But that's basically the answer, right? Participating agency or child find information you can share. Otherwise, generally, you need parent consent.
Thank you. And I've seen a lot of those questions pop through. If these discussions, spur anything that you want to go talk about a little further later, we are going to have a Q&A session. So, be sure to go and drop all those questions in the chat. We will try to get to as many as we can. So let's go move on. We hit the next slide. Let's talk a little bit about transition. So just hypothetically, child's approaching age 3. Part C system is ready to conduct the transition notification to the SEA and the LEA. So can you talk to us a little bit about what PII can be shared at transition, and any sort of opt-out policies that must be adopted by the SEA?
Yep, absolutely. So transition, there are lots of different parties involved. For Part C, it's going to be the early intervention service provider who has an obligation to notify the state educational agency and the LEA and reports that data through the SBP APR. So at a minimum, there's the LEA notification requirement for children who are turning 3 at least 90 days, not more than 9 months before their 3rd birthday. There's a certain number of steps that have to be taken in the transition context, developing a transition plan in the IFSP, conducting that LEA notification so that the LEA can start to reach out to the parent, and ultimately holding a transition conference. And for all of those steps, you have to think through, as you already know, if you're not if your state lead agency is not the state educational agency, you're a non-SEA lead agency, and your providers are not LEAs, you really are talking about figuring out, like, what kind of information can I share? And if you don't already have an existing data sharing agreement, you might want to think about doing that. This is really critical to helping Part C and Part B jointly serve children and ensure continuity of services in a seamless manner. That is something that I would strongly encourage you to consider, and at the state level. You may not need it at the local level if you have a strong enough agreement at the state level, but that local level agreement is also not a bad idea. The reason being is that in order for the LEA to attend a transition conference, you're going to need consent from that parent to disclose personally identifiable information, right? To provide that notification information. You don't generally need consent because as I said, it's considered part of child find, and both Part B and Part C have a child find mission. However, when we finalized our 2011 regulations, we did codify an exception we had in our prior non-regulatory guidance and letter to elder, where we allowed states to have the option to let parents opt out. It has to be a statewide policy adopted at the state lead agency level, to not share that child's name and date of birth and the parent's contact information, including what language that parent may speak, as well as the name and information and contact information for the service coordinator who served that child. All of that is child find related information in general. That too can be shared without parent consent unless the state has adopted an opt-out policy. So if there is information that the LEA needs, such as the IFSP and a current evaluation, because they want to expedite the Part B evaluation process, can they receive that from the Part C early intervention service provider without parent consent? Generally, no, if those are being administered by two totally different entities, unless there's some sort of agreement and or the parent has provided consent. And similarly, there's an obligation on Part B's side for a child who is eligible for Part B services to ensure that that IEP is developed and implemented by the child's third birthday. To make that happen in a seamless manner, Congress added the requirement that the LEA be invited, or not that be invited, that the LEA invite the service coordinator at the parent's request to that initial IEP meeting. And our regulations reflect that as well. But again, to invite the service coordinator from Part B's perspective, you too may need to get parent consent. One thing I would recommend is if you don't have already a streamlined form for transition where consent is obtained from the parent at the get-go, both for the Part B purpose and for the Part C purpose, you might want to look at your consent form, because that combined consent, if you do it right up front, is easier than coming back to the parent multiple times if that child is determined eligible and you're trying to get that IEP in place in a very quick way by that child's third birthday.
Thank you, Kala. Can we go to the next slide? So, Kala, all this talk of consent, I mean, consent is hard sometimes. Isn't there just some kind of, magical exception or maybe a written agreement that will just make all of this just magically easy for us?
Yes. Ross, you
So-
do this privacy work.
Okay, well, let's kind of drill into the details here. So, say we have a IDA agency or maybe a provider. They're asked to share PII and data with another agency, such as, let's say, EDI or Head Start, for children served under IDA. So, let's go ahead. Next slide there on that.
As I said earlier today, there is an exception. Frank identified it, which is the audit evaluation exception. And it's not the audit part, it's audit or evaluation. It's the evaluation exception under FERPA that was added in 2012. And it's codified in the IDA Part B and Part C regulations by cross-reference. This exception allows limited data sharing for very specific purposes to ensure that evaluation of the program and outcomes and purposes of the programs are being met. And when I say programs, I'm talking about the IDA programs, whether that's Part C, preschool, school age, Part B. This is not an exception to be used to track a child. As a parent myself of a child with a disability and a sibling of two sisters with significant disabilities for whom I served as a parent, it's really important to me and to the Department of Education that this exception is not intended for any purpose for tracking a child or predetermining services or what a child's potential is. The purpose of this exception is just what it says. It's to evaluate. Evaluate, are we being effective in serving children? In order to use this exception, this is the order in which you have to think about it. And I mentioned it earlier. First, for what purpose is this data being shared? Is it to determine like, oh, I want to make sure transition is smooth and that that child ends up in a program where he or she needs services? Second, what are the outcomes that you're looking for? And from the Part C perspective, if you were going to designate, say, the Part B preschool program as an authorized representative through an evaluation exception, it would be that you would want to know, hey, when we identified this child, let's say at age 2 later, maybe they were referred later, and we identified some communication delays, what kind of results did we get? Not just for this child, but generally. For the children who we had communication delays, what were their reading outcomes or preschool readiness outcomes for kindergarten? So what kind of outcome information would be helpful to us as we evaluate our Part C program and what services we're providing? And then the third question, which is the last of these three, is what data elements would you need, and are they even available? Part B 619 may not collect school readiness data. They have some data. They have clearly child outcome data that they collect because they report that to us at the U.S. Department of Education under their SPP APR under IDA Section 616. But are there other data elements that they may have access to that would help you solve some of the questions of how do you effectively reach all children to identify children with disabilities as early as possible? These are the things that you need to bring the programs together. And it may be an EDI program, it may be a Head Start program, it may be another program that's not part of your participating agency, but with whom you need to have some level of data sharing. It's not data sharing that would permit everyone to have access to that data, necessarily all teachers, but it would be limited for the purpose that's described in the agreement. And it would only include, it would need to identify what are the outcomes as well as what data elements and who would have authority to share it. You could not redisclose that data, but it would give you insight on how effective your program is. And the preschool program can do this, the K-12 program can do this. And all of these steps are necessary and required before you can move forward with these different agreements. We did put together some resources, and I will talk about what steps we went through with CDC in an example of an agreement that we developed.
So let's go ahead and hit the next slide here. And actually, since we're talking about written agreements, kind of, Paula, what would come first in this process of, whether we're using this evaluation exception or not? Does the written agreement come first, or does the determination about whether or not you could use the exception come first? Does the written agreement come at the end or at the beginning?
It comes actually at the end. It's the end result for sure. And I think maybe I'll ask Frank to talk about this because in part it's the FERPA exception. So I also want him to reiterate under FERPA what some of the requirements are before we talk about some examples.
I would love to, Kala, and just to address something that my dear friend, Mr. Lemke, said that I want to make sure was taken in joke. There is no magic dust that allows a disclosure to occur. And I think and I say that in jest because we hear a lot. We have an MOU, we have a data sharing agreement. So that's all we need to share data. And unfortunately, that's not accurate. It has to be predicated upon something. And more than likely, it's going to be the audit or evaluation exception. So as Kala said, the written agreement really kind of seals the deal with the audit or evaluation, and more so the evaluation. You're going to be sharing information with some entity to do an evaluation. Are we realizing certain outcomes for the money we're investing in the early intervention services or the preschool 619 services? Kala and the previous slide hit a lot of those big things that you want to talk about. What is the outcome you're intending to get? What do you want to learn? And then what data elements are needed to do that? More than likely, you're probably going to have, again, either a researcher or some public university do this evaluation for you. And having worked with a lot of those entities over the years, they want all the data they can get. They want to get data upon data, a lot of which they don't need to determine the outcome that you want. And I think I say that because as the program, you're in control, not the researcher or the university or the entity that's doing the evaluation at your behalf. So just remember that and that really parlays into what needs to be in the written agreement. We won't go over it now, but in the resources, we have some sample agreements, but those things of who's going to have access to the data? What data do they really need? How are they going to make sure that it's protected and it's not redisclosed without your consent? How are they going to use the data? And also, how's it going to be destroyed when it's no longer needed for the specific purpose that you shared it? Those are all things that sometimes you may get, well, here's our standard boilerplate agreement that we use with everybody. Just sign it like everybody else does. Be careful with that. You're the driver. as Kyle said, the agreement at the end is kind of shores everything up, but you're the driver on that, not the entity that's doing the evaluation for you. So you have those things to consider as you're developing those written agreements.
Thank you, Frank. And we're going to go, you mentioned resources. I think that is a fantastic segue. So let's go, and we'll quickly go through resources here because I want to spend more time on the questions and answer. We could go ahead and hit the next slide. So, go ahead.
I was going to talk about these two in particular resources. Sorry, Ross, I just wanted to mention, as I said it earlier, there was an example. The agreement or the document screenshotted on the left is a partnership that that ECTA, DAISY, and NCHAM had under EDDI to develop resources for data sharing agreements between the EDDI and Part C programs. And there's a checklist on their respective websites that's very useful. And that really is the first step. The first step is meeting and identifying what are the common interests, what are the common not data elements, but what are the common purposes and outcomes. The agreement on the left, that screenshot that looks very technical and legal, is an agreement that I worked on. It took almost 2 years, and we worked on it, the U.S. Department of Education and the Office of Special Education Programs, but with our CDC partners. That was under the Autism Developmental Disabilities Monitoring Program, where they came at the state level to, they usually fund about approximately a dozen sites every 2 years, and they want to obtain outcome data for children with autism. And they're looking at surveillance data where they catch snapshots of the prevalence rates, but their data were pretty poor. They didn't have access to a lot of information. So they came to the IDA programs, Part C, as well as the preschool programs. And they started to say, hey, we need all this information. And thankfully, a lot of the state IDA programs reached out to us and to me, and we spoke with them and said, yeah, what are we getting out of it, right? The purpose of an evaluation, it's not a one-way data sharing. It's not that is not what you can use an evaluation exception for. So if that part is not clear, if you get nothing out of this, it is really, as Frank said, the IDA program is in the driver's seat. You get to decide, what is that information? What is it needed for? And how do I get information back that's helpful for the IDEA program? So it's important to identify the IDEA outcomes. That agreement is a good model. We put that template up both on the DAISY website, and it's also on the CDC's website. We work extensively with CDC's General Counsel's office and myself to come up with a template that lists potential outcomes, but it's not a boilerplate. You have to meet individually at the state level to determine what are the outcome pieces that you're looking to address and what information would be helpful. It's an example in the autism space, but it can be used in other areas as well. So I wanted to point that out, and that will be on the DAISY website. With that, I'm going to move this to, I guess it's Ross maybe, or Sharon, who's going to talk about some of the other resources.
Yeah, let's go ahead and go through the next slide here. So we're going to talk about some resources that are available not only on the DAISY side, but also on the PTAC's studentprivacy.ed.gov side. On the DAISY website, I want to call out 2 resources. So the IDA Part C, early hearing detection and intervention, EDDI. So the data sharing agreement checklist. It was jointly developed by DAISY, ECTA, and NCHAM, which I'm probably butchering the pronunciation there. Then the next resources, the IDA Part B, Section 619, and IDA Part C. Specifically, it's a data sharing agreement template developed jointly by ED and CDC. Let's go ahead and go to the next slide because I do want to get us over to the Q&A. So I love the resources on the studentprivacy.ed.gov website. I think the most important ones there, well, they're all important, but you should, if you haven't seen the IDA FERPA crosswalk, absolutely take a look at that. We run a student privacy newsletter. It's essentially our good old-fashioned listserv. We only send something out once a month. This is how you get informed of any new material that comes out of the Student Privacy Policy Office. So please, if you haven't already, sign up for that. And then there, this last bullet here talks about a early childhood FAQ. It is back for, what was done back in 2016, but there's still a lot of really good information in there that's still relevant today. Let's go ahead and click the next slide here. We talk a lot about written agreements. This written agreement checklist, it is one of our older resources. It is probably one of the ones that we refer to more often than anything else. That and the guidance for reasonable methods. Lots of questions about the use of audit evaluation exception. Lots of questions about written agreements. Frank and I kind of laughed about it a little bit because we hear it all the time. I can do whatever I want. I have a written agreement. We, on some level, we don't care about the written agreements until we know about the exception. So if the parties that you're working with don't understand these things, be sure to point them to some of these resources. So as you're negotiating these data sharing situations, you can sort of understand the perspectives of both sides. Mapping data flows checklist is a very helpful resource as you're trying to kind of map elements across agencies. And then we have a data sharing checklist for IDA Part C and Part B 619 agencies. You'll find that on the DAISY website as well. Let's go ahead and click right through one more time. And without further ado, let's go ahead to Q&A.
Thanks, Ross. Appreciate it. And thank you, the DAISY website. And you will receive an evaluation survey by email. And it's the email you use for registration. And please, we really use this feedback. I know that Carla, Ross, and Frank ask for it. So please go ahead. We really appreciate you being here. Please join me and let's thank our panel for doing this. And we are about 30 seconds over. So on that note, anyone want any last word before we adjourn for the afternoon?
No, I just want to thank you, Sharon and Ross, and your whole team, Grace, others, Allison, and of course my partner Frank, who's used to being my collaborator in this space. We really appreciate your putting this program together. So thank you.
Thank you, Carla.
Yes. Just want to echo that. Thank you so much, everyone. Glad you able to participate. At our student privacy ed.gov website, there is a link to ask questions. So if you have questions, this doesn't have to be a once and done. Feel free to submit those questions. I know Sharon has questions. If you get them to her, we partner all the time. So feel free to ask those questions that you're probably going to have after this session. Take care.
There is no wrong door to knock on. Just if you have the question, ask. If it's not meant for us, we will get you in touch with the right person.
That is a great
right.
last word. Carla, you get the last word. What is
last but not least, I want to thank you guys for doing the work you do. Really. I know you don't do it for the big kudos, the fame or the glory or the money. So thank you. Take care.
Thanks to all of you for all the work you do with families every day.